And this area is also equally and one of the very important areas, subjects that all advocates and law students have to concentrate. And wonderful practice must be awaited in this area also. It is a specialized, but basics and also sir is well versed. Everything is fingertips sir has got, and will be immensely benefited with this lecture. So thank you, and let's make use of it. Thank you very much. Thank you.
Now I invite our speaker, Sri Gauri Shankar sir, to address his lecture.
Dear friends, I am very happy to come over here and share my experience along with you. First of all, Mr. Ramchandra Reddy, my colleague. I completed law 1983 December, examinations have been completed. 84 I got enrolled. From 1988 onwards, I am practicing the High Court. And this Consumer Commission was also established during 1988. Prior to that, for a short period, I was at Guntur district, Nasrapet. I filed one case against AP's RTC, Nasrapet depot, and RTC chairman. Nasrapet, you might be knowing, there's a small divisional headquarters. But in spite of the same, there were about 6 or 7 bus stands. Guntur bus station, buses going to Guntur. One place the buses will stop. Some buses going to Palnadu area, in another part of Nasrapet town. From that, they will be shipping. And Satrapalli other bus stand is there. Vinukunda other bus stand is there. Kotapakunda other bus stand is there. There are about 4 to 5 bus stations are there. Though that bus RTC complex was constructed about 60-70 years back, new building complex has been constructed. In spite of for 2 years, the complex was not open. The then local MLA and former Minister of Nasrapet, he was waiting for the appointment of the then Chief Minister T. Ramarao for opening this bus complex. He was not at all giving any appointment. So, though the RTC complex was constructed and RTC people are collecting fare up to bus station, they are not operating. So, all the buses used to shuttle from 6-7 private bus stations. One consumer association called Universal Consumer Association, Nasrapet. For that, SSN college principal, he was the president of that NGO. He brought that case to me. So they are charging fare up to bus station. Some private bus stations are about 2 kilometers, 3 kilometers from the main bus complex. The children, old age people, or with the luggage, it is very difficult. They have to engage autos or rickshaws. So why should not they open bus complex? So with the grievance he came to me. I filed a complaint in Guntur District Commission, District 4, at the time it is called 4 District 4. I filed a complaint before Guntur District Forum against APSRTC. The District Forum directed the authorities to open bus complex and start all the buses from RTC complex. Against that, without implementing, they preferred appeal before our State Commission at Hyderabad, a combined state of Andhra Pradesh. For the State Commission, at that point of time, Justice Lakshman Rao was appointed as the President of State Commission. Members were also not appointed. No separate staff was appointed. Only High Court staff they were working, and members were not appointed. In the chambers of Justice Lakshman Rao, this case was first time it was heard. At that time, Reddy Garu, subsequently he became High Court judge. He was a standing counsel for APSRTC. They came and filed appeal. In that, I opposed it, stating that they are collecting fare up to bus complex. And we are not at all concerned about the reasons why bus complex is not open. And then the State Commission confirmed the orders passed by the District Commission, Guntur, and directed all the buses to be operated from RTC complex. At the time, I was practicing as a junior advocate at the Nasrapet Guntur district. So from there, I came over to, I have gone to Guntur and filed the case at Guntur District Forum and appeal This is the first appeal before the State Commission of Andhra Pradesh at that time. So first judgment that came in our favor. That was also published in Andhra Weekly Reporter. At that time there was a just like a ALP or ALD. Andhra Weekly Reporter was there. In that it was published. Thereafter I have shifted my practice in 1980 I have shifted to Hyderabad and practicing High Court. Subsequently, during the period only, State Commission, other members have been appointed, some staff have been appointed, but up to 1993, State Commission functioned from High Court premises only. Then registrar, assistant registrar, staff, members, about 30 to 40 members have been appointed for infrastructure to the Consumer Commission. Then High Court was not able to accommodate for all those people. They searched other building at Hyderabad, and from that place, State Commission was shifted to Hyderabad. I used to practice, though I was practicing regularly at High Court, I was doing both the consumer cases and this High Court work because of the shifting of State Commission from High Court to State Commission. Because in those days I used to have minimum about 20 cases before State Commission. So I was constant to choose to practice either at High Court or at the State Commission at Hyderabad. Because I got a number of cases, I have given the practice at the High Court and confined to this State Commission at Hyderabad. And I also appearing before the District Commissions Hyderabad and Rangareddy. So with that, I got a little expertise in that field. Anyhow, in 1988, I met Mr. Ramchandra Reddy. From that day onwards, we are continuing our friendship. For inviting me and asking me to share my views and experience in this field. Before you, thank you very much for inviting me, Parsadi Garu, Chakramani Garu, and Chandrakant Garu, and other friends. So, because already some of them friends are practicing advocates, and most of the students, law students, this Consumer Protection Act is one of the subject, and in even in academic subjects also for BA or become commerce, economics, commerce, MBS, MBA course also, this consumer protection has become one of the part. So that this has become very much important for all the students for various branches, and more particularly for law students, more apart from the practicing advocates. I don't go into the definitions part just like academic or lecture like regular lecturers. Just I will briefly introduce the subject, what is relevant, some important judgments, and thereafter we can have some interaction because you are practicing advocates and well-educated students. So, as rightly said by our friend, that all of you came from different places by different words. So, everybody is a consumer. Whoever purchases goods, whoever utilizes the services is a consumer. Purchase of goods means from morning to night, from dawn to dusk, from birth to death, from womb to tomb. Everybody is a consumer. Every day we purchase so many goods for a household, or a food purpose, or clothes, or vehicles, or so many things. So many articles, goods we will be purchasing. Goods means only movable goods, not immovable goods, immovable things like factories, industries, sheds, or lands. They are not called as goods under consumer protection. So purchases of goods and service, hires of services. Service means banking, insurance, financing, check funds, real estate, medical services, railways, roadways. So from them we don't purchase anything, just we will hire the services, we will utilize the services, we will avail the services. So purchases of the goods and hires of services by paying consideration. So for purchasing anything you have to pay money. Or on trade basis also, some amount some consideration will be there. So consideration means it may be cash or kind or a thing to do or not to do. You know very well. So purchases of goods for consideration and hires or utilizers or availers of services are called as consumers under Consumer Protection Act. For instance, there are some exceptions. So purchase of all goods are not consumers. Goods purchased for commercial purpose or goods purchased for resale. So such people are not considered as consumers. So any goods purchased for self-consumption or personal use, then only we will be called as consumers. Suppose in a factory is there, some industry is there, or some shop is there. Shopkeeper for the purpose of resell the goods. If you purchase some goods from a wholesaler, if there are any defects in the goods purchased by the shopkeeper, he cannot be called as a consumer. He will not, that fellow cannot be considered as a consumer, he has to go to regular court. So goods purchased for the purpose of self-consumption or for our family members or for any other, with our permission, any other person uses, they are also called as consumers. Suppose I purchase provisions for my house. My family members, they will use all the goods. They are also consumers. I may be direct purchaser. Even the beneficiaries are also called as purchasers, as goods, beneficiaries. Suppose this hall is there. This belongs to Sundarya Vignan Mandir. So they are having electricity. Suppose there is something that happens suddenly to electrification or something happens. Not only institute, with the permission of this institute, we all of us joined here. We are also availing the electricity. So we are also consumers. So Sundarya Vignan Mandiram, they are paying regular electricity charges. Still, with their permission, we came here, we are utilizing their services. We are the beneficiaries. So, with the permission of the first purchaser, any other person uses or avails services or goods, they are also called as beneficiaries. Beneficiaries are also consumers. So, purchases of goods, except goods purchased for resale or for commercial purpose. Suppose any industry is there, a factory is there, so or any big institution is there, for the purpose of production of their, for maintaining production. If a factory purchases a very big generator, if there is a fault in the function of the generator, that factory owner cannot file a consumer complaint because that generator is purchased for commercial purpose to make money, not for personal consumption. So, or suppose for the managing director of a company, a car is purchased in the name of the company. If there is defect in the car, the company cannot file a case as a consumer. If the individual capacity, if the managing director purchases a car for his personal use, then if there is a defect, he can be called as a consumer, he can file the case. So, whatever goods we purchase, if they are movable, unlike immovable properties like lands, buildings, sheds, so all the goods, whatever we purchase for our personal consumption or for the benefit of family members or friends, even the beneficiary is also consumer of goods. Similarly, service I told you. Service is a very big, it includes each and every service except specifically exempted. So it is inclusive definition. It includes each and every service unless specifically exempted. So it means availing the services. Any person whoever avails the service is a consumer. Like they have in the definition they have mentioned, like the service like banking, insurance, financing, electricity, or telegraph serving remote, or like transportation, or delivering of news, boarding, lodging, or any other service, whatever service we use. There are also two exceptions. There is also one exception, services available for commercial purpose. Suppose an industry takes 1 crore loan for the purpose of their commercial purpose. If any dispute is or any problem is there or any fault at the part of the banker in providing service to that industrialist, he is not a consumer because a big factory or big organization meant for earning profit. So that's for commercial purpose. And services provided free of service, free of charges. Services provided for free of service, free of charge. If there is no consideration, suppose you take government general hospital. For all the patients, the services will be rendered free of charge. If you go to a private hospital, 100% they will charge from the patients. In the government general hospitals, for each and every person, the rich and poor, they will provide free service. So, though we are availing the service from government general hospital or a charitable hospital, like a Satyasai Institute, like a Puttaparthi is there, even if heart operation is done, then everything will be free there. Or in either Lions Club, sometimes some camps they will be conducted. So there also they won't take any fees or consideration from the patients. So this, though there was service provided by the hospital or any charitable hospital or a government general hospital where there is no fees, where there is no charges, even if there is admittedly there is deficient service, because of the negligence or deficiency on the part of the hospital or the doctor, if the patient dies or the disease increases, still under Consumer Protection Act, we cannot be called as a consumer because there is no consideration. Consideration is mandated for purchasing goods. Similarly, in availing services also, consideration must be there. So, in services, two exceptions. Services rendered free of charge will not count. Similarly, contract of personal services. Contract of personal services are also exempted from the purview of this act. You know, contract of personal service means that is a relationship between master and servant, employer and employee. So, an employer will avail the service of an employee. Similarly, employers or any boss, master and servant. So, the servant or this person cannot file in a case saying that my boss is not giving salary or not transferring or like this, a pension is not paid, provident fund is not paid, or the like any other grievances by employee against the employer, because that is a contract of personal service that is specifically exempted from the purview of this act. Or suppose provident fund, this is a central provident fund will be there, or a state government provident fund, they will contribute, both of us will contribute. That amount will be there's some provident fund thing that is like a fixed deposit. That specifically against those who can file. But other things, transfers, promotion, suspension, increasing of salary, payment of arrears, regarding all those service matters, the employee cannot be considered as a consumer. So, consumer complaint, insofar as this contract of personal service specifically exempted. So, all other purchase of goods and hires of services are consumers. And the problem is, so what is the problem with the consumers? Whenever you purchase goods, sometimes there will be defect in the goods, deficiency in services. And insofar as the quality is concerned, price is concerned, purity is concerned, standard is concerned, in the specifications are given by the trader. If they are not satisfying, the goods supplied to us are not satisfying the specifications, or the goods supplied by manufacturer or trader are not up to mark as per the government norms. If they are not up to standards, or weight is less, or adulterated, or spoiled, quality is less, and some medicines you purchase, some medicines they are not up to standard. I mean, misbranding of the drugs. Suppose in paracetamol tablet there must be 500 mg in every tablet. Suppose when it is seized and sent for laboratory, it is found to be only 400 mg instead of 500 mg. That also substandard. Quality is not there. So whatever specifications are offered in the agreement, or whatever as per the norms of the government, or as per the statutory duties, statutory liabilities, if they are not performed by the vendor or manufacturer, that amounts to defective goods. Similarly, whatever is promised by them in the brochure, whatever promised in the agreement specifications, and whatever as per statutory norms, they have to comply. If they are not complied, that amounts to defective good. Similarly, service also similarly same thing. Service quality and other things. Similarly, whenever they fail to perform whatever they promised, that amounts to deficient service. Similarly, adoption of unfair trade practice. Unfair trade practice means, for the purpose of promoting the goods, promoting the services, the traders or manufacturers will represent so many things, saying that we will give guarantee for 5 years or 10 years or like this, and price thing, and so many things they will represent at the time of disposal of the goods and services. Only for the purpose of promotion of the goods and services, if any representation is made far from truth, without any, simply the time of sale, they will say that we will give guarantee for 5 years or 10 years. After purchasing the TV, reposing the confidence upon the trader that they will repair the defect, if any, in future for 5 years. Subsequently, if the defect occurs once or twice, they will repair it. Subsequently, they won't look, they won't respond, they won't even repair it. So it means whatever promises made by them found to be false, representations made found to be false representations, misleading advertisements, either newspapers or TV channels or any electronic mode, whatever may be. So these advertisements, misleading advertisements, selling second-hand or brand second hand or repaired or reconditioned things as brand new. And similarly, education, so many education institutions will be representing that we are having affiliation from so-and-so Darbhanga University or so-and-so Commercial University or so-and-so. So without having proper approvals from competent education institutions or UGC or from universities, without having proper approvals or Medical Council of India, they join the students and finally the students are not permitted to appear for the examinations. This amounts to unfair trade practice. Misleading advertisement. Unfair trade practice, if you go through the definition of Consumer Protection Act, it is about 1.5 page definition is there. So many things. So conducting lotteries, puzzles during festival season, we'll be seeing that every showrooms, particularly cloth showrooms, they will give one open free of cost. They say we'll give 1 kg of gold free of charge by after conducting lottery. We will conduct games of skill, games of puzzle. So many things. We'll give a lottery buy of one plot free of cost buy of lottery. So these are so many representations made by them. Or selling second hand, or misbranded, or repaired, or reconditions without the approval of the competent authorities. So making such representations amounts to unfair trade practice. So because of the unfair trade practice, because of the inducement made by the traders and manufacturers, if we buy, and subsequently the trader and manufacturer fails to perform in future, warranty and guarantees are given for 5 years or 10 years or 7 years without any intention to perform the same in future. All those things amounts to misleading advertisements and unfair trade practice. So whenever a trader or manufacturer adopts such unfair trade practices, because of the unfair trade practices, we suffer. If the consumers suffer, we are also entitled to approach consumer commission. Similarly, restrictive trade practices. Suppose a 10th class student wants to purchase English textbook. The boy goes to any bookstall. The bookkeeper, stallkeeper will insist the student to purchase guide. If you purchase the guide, I will sell the textbook. So in textbook they may get a 9 to 10% profit, whereas in the guide 50%, minimum 50 to 60% profit they will gain. So compelling a consumer, if they want to purchase one thing, they will compel the student or the consumer to purchase some other thing. So this is called a tie-up sale or restrictive trade practice also. If any such practice are adopted, the consumers suffer. Then also consumer, that person to be called as a consumer. So a consumer, whenever he suffers because of the defect in the goods, deficient services, unfair trade practices, restrictive trade practices, excessive prices, or duplicate goods. So the person who sustains loss is a consumer. He is entitled to have a remedy. Remedy is some kind of justice. Sorry. So every consumer is entitled to have remedy. Justice, entitled for justice. So this consumer protection is not a new concept. Even from Arthashastra onwards, in olden days, if any trader adopts food products and oils, something is mixed, adulteration, food adulteration takes place. So there used to be severe punishments like cutting the hands or heads like that. So in a civilized society, throughout the world, in each and every country, there is expectation of consumers. In some countries where the education is more, people are aware, and standard of living is more, when they are aware consumers are there, this expectation is less. But the countries like underdeveloped countries or developing countries, where rural areas or tribal areas or like this, where education is less, where the consumers are not conscious about their rights, this consumer exploitation is going on. So for protecting and promoting the rights of the consumers, this Consumer Protection Act is not the only solution. Prior to this, we are having in India about 3 dozen acts from prior to independence also. If you take from Contract Act, Sale of Goods Act, Extension Committees Act, Prevention of Adulteration Act, Drugs and Cosmetics Act, Legal Metrology Act, Bureau of Industry Standards, ISMR. So, so many, even Electricity Act, Railways Act, so many enactments are there. The purpose of all those respective acts are to protect the rights of the consumers. May not be directly, some are directly, some are indirectly. So, for protection and promoting the rights of the consumers, already various enactments were already there. Even prior to independence. After independence, several new acts been enacted, some old acts have been amended. And in spite of this same, this consumer exploitation is going on. This consumer exploitation is going on throughout world, maybe some variation in some degrees only. Taking this, most of the consumers, particularly in India, were not very much conscious to go to court of law and were not very much determined to punish the fraudulent manufacturer service providers. We, particularly because of regarding the existing traditional civil courts, because of the costly litigation, complicated procedures, abnormal delays, most of the consumers, particularly in small matters, were not approaching any court of law. We are simply suffering in silence, taking advantage of our helpless situation. The consumers, the manufacturers, some of the unscrupulous traders and unscrupulous manufacturers are exploiting us. So this degree of exploitation is there. Exploitation is throughout world, but in our country, like underdeveloped areas, education less, this is more. So this taking advantage, taking this into situation, in 1985, UNO passed a resolution stating that the regular traditional courts are not able to render quick justice to the consumers. Consumers not approaching the courts. So this consumer exploitation is going on. To have an alternative to the regular courts, some separate enactments must be made in the respective member countries. Basing upon the resolution passed by UNO 1985, Consumer Protection Act was enacted in India in 1986. So for the first time, the purpose of the objectives and the purpose of the Consumer Protection Act is to provide speedy, simple and inexpensive justice to the consumers. So these are the objectives: to provide speedy, simple and inexpensive justice. The previous problems are costly litigation, complicated procedure, abnormal delays. They are the problems of regular courts. So to provide speedy, simple and inexpensive justice with these objectives, certain rights have been conferred to the consumers under Consumer Protection Act. They are called the right to safety, right to information, right to choose, right to heard, consumer education, right to redressal and consumer education. 6 consumer rights have been conferred by this act to each and every citizen, every person in India. So for protecting and promoting the rights of the consumers, redressal is also one of the right I said. Right to redressal, consumer redressal. So in case of any problem being faced by a consumer, to get the problem settled or resolved, that's one of the rights. So for protecting and promoting the rights of the consumers in a speedy, simple, inexpensive procedure, for the redressal of these disputes, a three-tier mechanism has been constituted in the old Act at a district level, state level, national level. That Consumer Protection Act 1986, according to that, at a district level, district commissions, they are called Consumer Disputes Redressal Agencies. Consumer Disputes Redressal Agencies. If you say consumer court, general public will think this is also another court. So instead of calling it as court, another terminology is called forum. So Consumer Disputes Redressal Agencies at the district level, district forum, state level, state commission, national level, national commission. This is a three-tier structure has been constituted. In the district level, from 86 onwards, I am not saying. So that the 1986 Act has been repealed and 2019 Consumer Protection Act, new Act has been incorporated. So by the time of repealing the old Act, the jurisdiction of the district commission is up to 20 lakhs. So any goods are, I will clarify. District for commission wanted jurisdiction 20 lakhs, state commission about 20 lakhs, and up to 1 to 50, then thereafter to national commission. So that jurisdiction, that is a monetary jurisdiction. Territorial jurisdiction is concerned, wherever the opposite party is residing, or wherever the branch office is there, or any cause of action, either whole or part arises, there the consumer can file the complaint. District level, will be presented, district forum will be presented by one sitting or retired district head, 2 more members. One must be lady. In state commission also, they are having original jurisdiction, appellate jurisdiction, revisional jurisdiction. They also, against the orders of the state commission, who have to go to national commission. National commission will be having original jurisdiction, appellate jurisdiction, and revisional jurisdiction. Against the orders of the national commission, we had to go before Supreme Court. This was the brief structure of the consumer forum. And the procedure for filing the complaint is, whenever we receive a complaint, period of limitation is 2 years. Even if there is delay beyond 2 years, there is a project to file the complaint with a delay application, explain the reasons for delay. Thereafter, after issuing notice, maximum 32 plus 15 days, 45 days is the time granted to the opposite parties to file written version. It is mandated. After beyond 45 days, no written version will be accepted. And based upon the material available, they will decide the cases. And normally, in all the consumer cases, based upon the written pleadings, documents, and affidavits only, and after hearing arguments, judgments will be pronounced. But in medical cases only, whenever party, any party, either consumer or opposite party requests, permission will be given for cross-examination. You can also adduce any expert evidence also. Even cross-examination, everything will be done. And as per Old Act, if any judgment is given, either the complainant or the opposite party is not satisfied. So if any aggrieved party not satisfied with the orders passed for the district forum, within 1 month appeal must be filed before the state commission. Some started for the complainant consumer for preferring appeal, no court fees is required. For the opposite party for filing appeal, some amount must be deposited. It's called a statutory deposit. Maximum according to the act is either 50% of the awarded amount or 25,000 rupees, whichever is less. Suppose 10,000 is awarded compensation. If the opposite party wants to prefer appeal, he has to deposit 50% is 5,000. Suppose 10 lakhs compensation awarded by the district commission. If the opposite party wants to prefer appeal, maximum either 50% or 25,000, whichever is less. It means 25,000 was the statutory deposit to be made while preferring appeal by the opposite party before the state commission. Of course, while granting interim orders, the state commission may impose any other conditions. So the limitation period is 2 years. Jurisdiction is there, monetary jurisdiction, petty jurisdiction, and control deliberation is there. For filing written version, time frame is there, and particularly in medical cases, we can also adduce oral evidence, and also we can cross-examine, and the mode of how the consumer commissions will grant reliefs. What are the reliefs? Normally, whenever any complaint is made regarding defective TV set or machinery or a car or something, so insofar as there is possibility for repairing it, the court will, consumer forum will direct the opposite party to repair it. If there is no scope for repairing it, if number of times repairs have been done, and there is no possibility for any solution, in such if it is not at all possible to repair it and put in normal condition, in such cases, instead of repairing, the forum will direct for replacement of the the defective wood by a new vehicle. Sometimes in deficient service will be there. In the service also some deficiency is there. Whatever deficiency pointed out in the service will be directed to be rectified. Another thing is, we will, by approaching the Consumer Commission, by having the defective TV or defective vehicle, or because of the deficient services or the goods, we will be having some mental item. For that, adequate compensation will be afforded. Apart from that, the Consumer Commissions, either District Forum, State Commission, National Commission, whatever may be, suppose in batch cases, suppose if you purchase some tablet, so each and every medical manufacturer in a batch case, in a batch of tablets production, minimum 50,000 or 1 lakh, more than 2 lakhs, 3 lakhs like that, the tablets will be manufactured. On analysis of one tablet, it is found to be defective or substandard or adulterated. All the tablets in the same batch, maybe 10,000 or 20,000 or 50,000, whatever may be, all the entire product will be defective. So in such cases, the Consumer Forum can direct, first of all, to stop from offering to the public the sale of, to stop the sales. Don't offer to the public. That the direction can be given. Whatever stock lying in the shop or in the market, the Consumer Forum can give directions to the manufacturers to withdraw the stocks from the market or from their shops. And in some cases like production also, the Consumer Forum will direct them to stop cease and that's called cease and desist orders to stop the production. So Consumer Forum is entitled to give direction to the manufacturer to stop the manufacture of the particular product. And in some cases, advertisement might have been given with misleading representations, false representations. Already advertisements are going on in TVs, papers, and electronic boards, so the board. So the Consumer Forum can direct them to stop the advertisements, and they will sometimes give directions to the manufacturers to give proper, corrected advertisements for the benefit of the public. Sometimes they will prohibit, don't advertise at all. So such directions they are entitled to give to the manufacturers or traders. In some other cases, where the consumers may be in hundreds of thousands and lakhs of members, unidentified people, unaccepted, they cannot ascertain how many consumers have purchased it. But the product is there in the market or production records are there. In such cases, a huge penalty will be imposed against the manufacturers. So, such a kind of directions can be given. Various one or two or appropriate directions can be given to the Consumer Commissions. So, this is the important thing. One more is implementation part. Suppose a direction is given by Consumer Commission to a real estate fellow to execute the sale deed of a particular plot in front of the consumer. The forum can give direction to execute the sale deed in front of the consumer. Suppose an apartment is there. So far as the housing construction activity is concerned, housing construction activity means real estates as well as the construction of flats, apartments, group houses, villas, all those things will come. So that is comes under housing construction activity. So in such cases, possessions are not delivered. If there is a delay on the part of the builder in handing over possession, if there is a building is not at all constructed or stopped in the middle, or abnormal delay is there, or registration is not done, flat registration is not done. In such cases, the Consumer Forum is entitled to, in appropriate cases, to refer the price paid by the consumer to the builder. So a refund of the price with adequate interest also be awarded. Or if the possession is not delivered, Consumer Commission can give direction to the builder to hand over the possession or the flat. If there is a defective construction, they can give directions to complete source of particular problem. Some common amenities or internal amenities will not be provided by the builders. So whatever common amenities like demarcation of parking area or cellars or lifts are not provided, terrace is not completed, greenery is not provided, or any other common amenity or internal facilities are not provided, appropriate directions can be given by the Consumer Commissions against the builder. In some cases, though there is judgment against the opposite party or builder by the Consumer Commission to execute the sale deed. Sometimes the builder will run away, they won't implement the order. In such cases, if non-compliance of the orders, there are two ways for the consumers. One is to file application for penalty petitions 2 times to punish the opposing party for non-compliance. Another is for execution. Execution means for attachment and sale of the properties of the opposing party for not implementing the order. So in most of the cases, we prefer to file earlier to section 27 that is changed for punishing the opposing party for not implementing. Then they will arrest once or imprisonment orders will be passed. So in view of threatening of arrest and imprisonment, most of the opposing parties used to implement the orders. In some cases where the opposing parties runs away, they won't implement the order. If they are having properties, we can file application for execution, like attachment and sale under RR Act, Revenue Repair Act, they can attach. Even new act, in the consumer for itself can register the sale deed. If the builder runs away, building is completed, possession is delivered, registration not done. So registration direction is given by the consumer commission, the opposite party for implementing register the sale deed. The builder runs away, whereabouts are not known. In such cases, the consumer commission itself can execute the sale deed in front of the consumer. So these are the remedies for non-compliance. So this is the basic structure of the features of Consumer Protection Act 1986 that has subsequently been totally repealed, and 2019 new act has been incorporated. Some more features have been incorporated. Mainly in the name of District Consumer Commission has been made as a District Commission. Now District Commission, State Commission, National Commission, and the jurisdiction of monetary jurisdiction has been amended, and even wherever the consumer previously as per the territorial jurisdiction, wherever the opposite party is residing or wherever the opposite party is having branch office, there we have to go and file the complaint in that particular district. Now, apart from that, wherever the consumer is residing, from that place, from that district, you can file the complaint. Suppose you go to for a meeting, you might have gone to some Delhi to attend a meeting, some conference. You purchase an electronic article from Delhi. After coming back to Hyderabad, if it is not functioning, previously as per the old act, we must go and file the case in Delhi against the vendor. But now, as per new act, wherever the consumer is residing, so in that place also we can file. So it means we can file in Hyderabad against the vendor at Delhi. Similarly, monetary jurisdiction is also enhanced. This is one important point I have to clarify. Previously, monetary jurisdiction will be decided based upon the value of the relief claimed by you. Whatever compensation you are asking, how much you are asking, how much interest you are asking, how much compensation you are asking, how much other reliefs you are asking. So, not only the total reliefs, not only the amount paid by you, total reliefs, total value is to be computed based upon the value of the claim, the jurisdiction will be decided. Now, the value of the claim is not at all relevant. The criteria for filing the complaint is what is the consideration paid by the consumer to the opposite party. Previously, suppose if you go to a doctor, because of the negligence of the doctor, if the patient dies, if you want to file a complaint claiming compensation of about 1 crore, or if you want to file claim 10 crores, what is the value of the claim made? 10 crores. For 10 crores, we have to file before National Commission directly daily. Whereas in the present act, value of the claim is irrelevant. What is the consideration paid by the consumer is important. So for a doctor or a hospital, you may pay about 50,000 rupees towards fees. The patient dies. If you want to claim 10 crores compensation for the negligence of doctor, now you have to choose the jurisdiction based upon the consideration paid by you. What is the consideration paid by you? Is only 10,000 or 50,000. So that is below the is in the jurisdiction of the district commission. Now, presently the jurisdiction of the district commission, the consideration is paid is irrelevant. So, up to 50 lakhs state commission, up to the value of 50 lakhs paid to the consumer, who have to file before the district forum. Above 50 lakhs and up to 2 crores, who must file before state commission, and above 2 crores only, directly you have to file before national commission. So, consideration paid by the consumer is important. I will give one more example. Suppose a big factory is there. You might have insured for 200 crores for the insurance of the factory. That fellow factory owner might have paid about 10 lakhs towards the insurance premium. The factory is burned. So as insurance is concerned, though it is a commercial purpose, the Supreme Court said that still he is a consumer. So the commercial element will not arise. So even a factory which takes insurance policy for 200 crores or 500 crores, whatever may be, the commercial element will not arise there. The Supreme Court has a subsequent clarified. So they now, or my simple thing is, a factory insured for 550 or 500 crores and fire accident occurred and he paid 10 lakhs towards premium, insurance premium. Now total it is bond. So it is asking 500 crores compensation. Insurance company rejected it. So that insurance company has to file consumer complaint. Where they have to file? Either Delhi or Hyderabad, district forum. Because the consideration is only 10 lakhs. Within the jurisdiction of district forum, in the district commission only, now we can claim compensation up to 500 crores. So, but for the criteria now for the purpose of deciding monetary jurisdiction is value of the consideration paid is important, not value of the claim made. So, that has been changed. And for filing the complaints, there is no procedure, same thing. And one thing is, a review provision has been given to district forum, state commission, national commission. Suppose any orders are made by mistake, error, patent error, or some other orders have been passed. So in such cases, we are entitled to file review applications before the district commission, state commission, national commission. Previously, there is no provision. And for filing appeal from district forum to state commission, 45 days, earlier only 30 days. So appeal period has been enhanced to 45 days. But for the state commission, national commission say 30 days. From the original jurisdiction of the state commission, suppose a complaint is filed before the district state commission, it was lost. If any either complaint or the opposite party wants to prefer appeal to national commission, only 30 days is the appeal period. But for the district forum period is 30 days, it is increased to 45 days. And ex parte orders, if ex parte orders are passed, there is no provision for either for the district forum or state commission to set aside, but to file only appeal or revisions only before the state commission. But for national commission, for the first time, the powers have been transferred to set aside ex parte orders. Set aside ex parte orders, such provision has been given. And so far as penalties are concerned, for non-compliance, previously 25,000, only up to 10,000, only fine can be imposed. Now that has been minimum 25,000 to 1 lakh fine is increased. Similarly, imprisonment up to 3 years is also increased. And one more important is CCPA, Central Consumer Protection Authority, has been constituted. Mainly, the main purpose of that Central Consumer Protection Authority is to act against unfair trade practices and misleading advertisements. So that central authority itself can either sue to take up anything where class action they can initiate, they can inspect any factory or any industry or any organization. If any misleading practices are going on, unfair treatments are going on, they can, or if any celebrities, cinema actors, or tennis stars, even celebrities without satisfying that whatever advertisement they are making or whatever representation they are making about in cars or something are as per totally 100% perfect, then only they can act without verification, without satisfying of the quality or whatever legalities of the product. If any legal, this any star, film star, any other celebrity simply add. In such cases, the manufacturer or producer of the short film or the endorser or publisher, including the celebrity, are liable for payment of minimum 10,000 compensation. If again it is repeated, up to 50 lakhs compensation can be imprisoned. Similarly, it also attacks imprisonment. Minimum 3 months to up to 3 years also imprisonment can be imposed. So, whenever large violation of consumer rights are going on, suo motu, this Central Consumer Protection Authority can take up the case. They can also that hang various other provisions, various other authorities. They can also file consumer cases. They can also get implemented in the pending cases, and they can also advise the government of India about various policies which are in favor of the consumers. Or they can also some kinds of emergency like a COVID or some other situations, emergency situation affecting the general public. They will give for the public safety alerts. Don't purchase this or don't involve this. They are unfair. They are cyber crimes. Don't become a prey for this advertisement like that. They will give so many alerts. And against the orders of that the Central Consumer Protection Authority, only appeal lies to National Commission. So, in so far as the administration of Central Consumer Protection Authority, as an advocate, we are not much interested. But if anybody wants to prefer appeal against that orders, only lies to National Commission. So, their filing of cases are contesting. Before that, also we can, as an advocate, we can participate. I will give you just 2-3 important judgments for information, and we can have some interaction. 3 important. We are getting number of complaints against vendors, real estate manufacturing, real estate selling vendors. There is one sector. We are also getting number of cases against hospitals and doctors. From districts, we are getting number of cases pertaining to defective goods by the cases filed by the farmers. And so as another thing is life insurance, medical policies, salary savings. So these are very important areas which the consumer commissions are getting cases. In so as filing of medical case, just I will give small thing. Before filing complaint against doctor or hospital, the Supreme Court already has given long time back several guidelines. Indian Medical Association versus VP Santa, about 92 or so itself, the judgment was given that holds good as far as the guidelines are concerned. Actually, my case also has gone to Supreme Court as batch matter. Various in the initial periods, most of the doctors have challenged it. So the various state commissions, medical cases have been filed against doctors in the hospitals. The doctors have challenged it, saying that the doctors are not amenable to the provisions of Consumer Protection Act. Or Andhra Pradesh State Commission held that against medical profession or doctors, Consumer Protection Act applies. Tamil Nadu is concerned that the state commission held no, doctors are not available. So like this, inconsistent judgments were there. Ultimately, all the matters are gone to Supreme Court. Indian Medical Association versus VP Santa. In that, the guidelines have been given. The Supreme Court said that all the private hospitals, private doctors, private nursing homes are amenable to the provisions of Consumer Protection Act. And only government general hospital or charitable hospitals where no fees is collected from each and every patient, such hospitals, complaint does not place because there is no consideration at all. And some cases where in a private hospital also some doctors will render free service to a particular patient. What may be the reason? Admittedly, private hospital has rendered service to particular patient free of charge. There is no consideration. In spite of that, in such a case, if the patient dies because of the negligence of the doctor or hospital, still the complaint is made. Supreme Court said that because from almost all the patients, the hospitals are charging fees from a particular patient for whatever may be the reason, you might have not collected charge. So the main basic feature of a hospital is you are collecting fees. It is not a charitable hospital, so you are liable. So in a private hospital, for a particular one or two patient, admittedly no fees is collected. If there is deficient service and the patient dies or disease increases, they are entitled to file the consumer complaint. Similarly, from the government general hospital, it is government general hospital complaint is maintained or not. Supreme Court said that this is a landmark judgment. Supreme Court said that in general, against all government hospitals where there is no fees is collected, even if there is negligence, they are not complaints are not maintained because there is no fees. It is argued that no, for government doctors, public is paying taxes or the taxes only, salaries are paid to the doctors, doctors are not attending free service. Supreme Court has clearly said that tax is different from fees or charge. Tax is a compulsory extraction of money, whether you like it or not like it, we are bound to pay tax. So that's compulsory extraction. At the same time, there is no reciprocal obligation on the part of government to provide all these welfare measures. Government general hospitals are provided as a part of welfare measures. There is no reciprocal obligation. And further clarified that in case of some even private hospitals also, or voluntary organizations, or charitable hospitals, or government hospitals, some nominal fees for registration, or like a token fees is collected, or for stationery, even if nominal amount is collected, even by private hospitals also, or in government hospitals also, you cannot, in government hospitals, that the token amount, registration charges, fees paid by you cannot be taken as a consideration. That is the thing. And even in government hospitals also, in some hospitals, this paying wards will be there. Paying wards for a particular patient. Some patients, AC rooms will be provided in government hospitals also. So they will charge. So whenever in private government hospitals, separate fees charges collected from that against that hospital, because you are charging money, the patient is entitled to file a complaint in case of negligent service. Like this, they have given various institutions like this established like clinics or diagnostic centers, laboratories, paramedical staff, for the negligence of paramedical staff, nurses or compounders or any other technologies, radiologists like this, or issue of wrong reports by investigation, all those things will come. So various guidelines have been given under Consumer Protection Act, saying except free services, all other services rendered by private hospitals, complaints are maintainable. That is subject to facts of each case. Facts of each case. I will suggest you in many cases because patients will come or they will come and file approach the advocate to file a case against the doctor. We being an advocate, we are not well versed with the medical terminology. Patients are also not aware of. Suppose any blood investigation or radiology, X-ray or any scan report or PET scan report, it is brought to before us. We do not know whether that report is in favor of the patient or against the patient, or if a case sheet is produced, we do not know where the doctor is at fault. Even if discharge summary is given, we do not know. So, if you want to file a complaint against doctor or hospital, we must take some other at least second opinion. You please ask the patient to bring either their friends or relative or at least MBBS doctor to come and assist us. So without any assistance, without taking any advice, it is not good to file directly the case based on whatever facts the patient says. The patient do not know, simply says he died. But the doctor, the case sheets or investigation reports or discharge summary, so many things they may write. Some are in our favor, or most of them are against us. Without doing anything, if we simply file the case based on whatever the patient said, it will be very difficult to win the case. So always better to ask at least some MBBS doctor, junior doctor is enough to go through the because it will be just like a small boy of 3 years chanting slokas or mantras. Without even we do not know, we are not experts, we can't read chant, though we will chant Sanskrit slokas, we don't know the meaning. So like this, always better to take the assistance of some doctor. And if you are applying for, then you please take some literature, medical literature. At least it will be available from the books also. So without knowing that, and also wherever possible, you please try to cross-examine the doctor. Or if you are appearing for the, and it is not bad to appear for the doctor also. So if you are appearing for the, on with the hospital doctor also, because it will be very easy for the advocate who is appearing for the hospital or the doctor, because the doctor will explain each and everything. What are the signs and symptoms of the patient at the time of admission? What are the clinical observations? What are the findings made? What are the investigation done? And what are the actual problem? What was the diagnosis made? And based upon the diagnosis, what is the line of treatment to be given? Is it by therapy, that's by medicines, or by surgery? If it is by way of surgery, what are the different types of surgeries are available? What are the pros and cons of each surgery? How much time it takes for surgery? Are any problems? Is there a guarantee in spite of undergoing the operation also, there is no guarantee patient will survive. So any inherent risk, that's called inherent risks. Sometimes even after operation also, 24 hours, 36 hours or 48 hours, the patient will be kept in observations. So diagnosis, rendering medical treatment, performing surgery, post-operative period, all are very much important areas when we want to file the case. Where the doctor is at fault, either diagnosis or final diagnosis, perform surgery, or in post-operative period. Sometimes the post-operative period, sometimes suddenly some problems will come. If doctor or nobody is there at the night, it will be aggravated. The patient may die. So sometimes I will give you one example. A patient for 3 years, 3.5 years baby, suffering with fever, doctor has written chloroquine injection. Nurse administered adult dose. Actually, baby 3.5 years. So because of collapse and died. I will give another example. I have done the case. A boy is suffering from Dulpet area. He is also for 5 years suffering from fever. They have gone to some hospital, Sikidarabad. Boy was anemic, lack of proper blood. So the doctor advised for blood transfusion. So they have gone to one blood bank at Sikidarabad. So instead of taking blood from outside, the paternal uncle himself donated his blood. They have packed the blood and given. And the blood is transfused and discharged. After 3-4 days, again that boy is suffering. And then he came to the hospital again. The routine they have conducted blood test. Then unfortunately it is found that he is suffering with AIDS, HIV, positive. Then the doctors have sent this boy, donor, paternal uncle, father and mother to that hospital. Only the donor and donee means paternal uncle who donated the blood and the boy who received the blood, both of them are suffering from this HIV. Parents are normal. Actually, if any patient is suffering from HIV, even if he is suffering, you do not know. For the surfacing of the problems, signs and symptoms, it may take sometimes 4 years, 5 years or 6 years. The patient will not be knowing. Unless the symptoms are exhibited, nobody thinks that I am suffering from this one, HIV, unless tested. Routinely, you don't go for any laboratory for test. Similarly, this tuberculosis, TB. TB also, there are different methods of testing TB. Some Montos test will be done. This is very most advanced technology. That one particle out of 1 lakh particles also it will detect it. If anybody undergoes that test, majority of us will be suffering with TB symptom, TB, but it won't be surface. In India, I am telling you, as per Indian statistics, about 20% of Indians are inherently having the TB that particles. We are having about 100, 125. Okay, let's see, 125. 25 of us, including me, will be inherently having some TB particles in our body. As per Indian standards, that is normal. But that Montos test cannot be done, that is not suitable to India. I will give you an example. This is L.S. Sumardi, High Court judge, subsequently became part-time court judge. His brother, retired from army, was suffering from some lung problem, cough. He has gone to one hospital. I think Apollo, I think, in those days. They have referred to some tests, they are not having that equipment. They have referred to some materials for somewhere else. That's called Montrose test. This is an advanced test. That revealed that some TB cells are there reflecting. Basing upon that, I think whether Apollo Hospital, I don't remember. In fact, I have run their case, or I won the case. Basing upon the findings of the Montrose test, the doctor detected that he is suffering from tuberculosis and advised treatment for 3 months of TB drugs. After 3 months, he again came back. 17 continued. After 6 months or so, again it is aggravated. Then he has gone to other hospital. It is confirmed that he is not at all having any TB, but suffering from cancer. TB cells and cancer cells will be, sometimes that is different aspect. TB cells will be looking as cancer cells, and cancer cells also will be looking as TB cells. So pathologist must be experienced person. Otherwise there is every scope for misreading TB cells as cancer cells and cancer cells as TB cells. That is a different aspect. But here he was actually suffering from cancer, and then he went to somewhere else, to Bombay or something. Thereafter undergoing treatment, he died. Then that case is filed with the State Commission by V.V. Rao at the University Council. After subsequently he became a High Court judge, that matter is given to me, and we have placed before the court everything. So he was suffering with a cancer, wrongly detected as TB. Unnecessary drugs have been administered for 6-7 months, and proper drugs were not administered. So, in detecting and diagnosing the ailment is important. Giving the treatment also important. Adequate treatment, adequate doses. If the drugs prescription is prescribed and the expected drug is given by medical fellow without verifying the same, if it is consumed, then it gets reaction. So, in the diagnosis, line of treatment, if it is a medicine or okay, or other surgery. In surgery also so many things will be happening. You don't know, we are getting so many hospital acquired diseases. So because of our stay, well, we may go to hospital some disease. We will acquire some other diseases, unnecessary diseases, because that's called hospital acquired diseases. So we must be very careful. I will give one more example. I got one medical case from Vijayawada. Lady has gone to hospital for cesarean, and the wife and husband, both of doctors, they have performed cesarean. Subsequently, infection developed, pus developed, very severely, serious. She was suffering very serious. Then she was shifted to another super specialty hospital in Vijayawada, Nagarjuna hospital, something. After undergoing treatment, she died. And they lodged a police complaint. Husband lodged a police complaint. These people also have thrown stones on the hospital. They also lodged another complaint. Okay, that case subsequently she died. So that case was referred by one law college lecturer, Siddhartha Law College lecturer in Vijayawada. He referred that case to me. That fellow husband is not much educated, only small person. He was working as a light boy in a Madras cinema area. I filed the case. Thereafter, opposite party entered a case. They also filed case sheet, everything, and said that there is no negligence at all. And particularly from Vijayawada, 5 doctors came to our state commission Hyderabad, because at the combined state, ready to give evidence, what evidence. I have to cross-examine without any intimation. 5 people came. Just Parvatara was the president of state commission at that point of time. Judge, he told me wanted to do at least a wife and husband, 2 doctors, you cross-examine. Because I have drafted the case, I have drafted the affidavit, I have cross-examined, I have not elicited anything. Then I asked to give some more time for cross-examining the expert doctors of other hospitals. 3 more doctors came. Then what it is, state commission appointed advocate commissioner to go to Vijayawada and conduct the cross-examination at Vijayawada. At Vijayawada bar session, all of us have gone there. That law lecturer, myself discussed together, who have cross-examined. I have not elicited anything, sir, even 0.11% also not elicited anything. The entire exercise is futile. And then it came for arguments. So tomorrow's case, just I was reading, I thought that 100% this case will be dismissed. Instead of that, we have to do something. Actually, I was seeing post-mortem report. Post-mortem report was there from the very beginning itself. In the bladder, there were 6 sutures were there. First time I have noticed. So, cesarean is a different area. No sutures will be there. For bladder, why sutures are there? It means while conducting surgery, they have mistakenly or whatever may be the reason, that bladder was also injured. It was sutured and it was never informed to anybody. Simply because of the infection of the bladder, she went into coma, septicemia, and ultimately she died. This fact was suppressed. They never mentioned the case sheet, they never mentioned the operation notes, or in the written version they never mentioned. Doctors also, nobody has said. First time, just 1 day before arguments, just I have seen and noticed the same. Next day I have gone to the court and explained to the judge, sir, this is the only thing they have completely suppressed. The patient, while performing surgery, cesarean, there was injury occurred to the bladder, sutures are there, and in the post-mortem report, the sutures are visible, they have clearly written. So, court clearly held that they have suppressed true facts and tried to mislead the court also and avoided huge complications. So, like this, against medical cases, against doctors, you can find the cases, and farmers also, hundreds and hundreds of cases who are getting against the seed suppliers. Seed manufacturers who are getting number of cases. So the main problems of farmers, they will purchase seed bags from traders. They will sow the seed. After there will be proper growth will not be there, germination will not be proper, growth will not be proper, fruits and flowers will not be proper, yield will be very less. Only after removing the plants, saying that, sir, we are, as per the representation made by them, for 1 acre of land, we are entitled to, we will get about 15 to 16 quintals of chilies. That is the promise made by the vendors. But whereas we get only 2 quintals of chilies one. So only after removal of the plants, no evidence will be there. Because you are also going to practice for filing the case on the consumer farmers, particularly is, so whenever any seed, whenever we sow, there will be germination will be there. They will mention 90 to 100% germination will be there. So if there is a defect in the seed, germination will be very less, 60%, 40%, 50% like that. That is one stage. So lesser germination of seed. After germination is satisfactory, then growth will be there. So sometimes the growth will not be proper. That is called stunted growth, particular shrinkage. So growth will not be proper. That is defect there. Thereafter, flowering stage. Flowers will be falling down. That is third complaint. Thereafter, yield is less. So whenever the farmer surfaces or notices the complaint, at appropriate time, the farmer must make a complaint to the dealer or the local agriculture officer, or he can approach an advocate. You can file a complaint. You can take an advocate commissioner and see you can note down the physical features of the crop. Similarly, for every mandal, there will be mandal agriculture officer, as well as for fruits and vegetables, horticulture officer will be there. So, if you lodge a complaint with the horticulture officer or agriculture officer, he will inspect and he will inspect the field, he will take the samples, he will send the samples to the laboratory, and the laboratory will give a report whether the seed was defective or not. Defective seeds will be, genetic purity will be there. First, growth, that is germination and genetic purity. Whether this defect or not, if proper test is done, the agriculture officer takes samples and he sends to the laboratory, and the report is in our favor. 100% will with all these things. So, at an appropriate stage, we must inform to the authorities. We have to get it inspected. We have to get the samples. We have to be sent to laboratory. In many cases, there may be some technical problems also. Suppose because of heavy rains, infects will attack the plants. Sometimes dry spells, for continuously there won't be any rain. Heavy heat, summer times, dry spells, that's called very much dry. All in such cases, yield will be less. So if you approach the authorities, they will probably get it. You please apply so-and-so pesticide, or you apply so-and-so manure, water is less. Or you do like this, proper remedial measures they may give, or you apply manures like this. So if we take these precautions, we can definitely win farmers cases who are from neighboring districts, hundreds of cases we are getting, Hyderabad, Warangal, hundreds and hundreds of the cases we are getting. Similarly, this this is the only important one. Then I will give for interaction. Insurance cases, particularly life insurance. So we will get each and every type of insurance except motor accident cases. Motor accident cases will not come. Life insurance cases will come. General insurance cases will come, and medical policies will come. Or electronic policies are for factories or industries or erection materials. All those insurance, all those things will come with our party. So general insurance, life insurance. Life insurance, you know that main problem in life insurance is the proposal form will be about 5 to 6 pages. Very small wording will be there. Number of questions will be there. If they are ladies or pregnant will be there. How many tooth you are having? And a cause will be there. And more particularly, apart from the source of income, salary, age, and also particular health condition for health purpose concerned about separate 6 questions will be there. What is your present health condition? Have you ever suffered any disease? Have you ever consulted a doctor in the last 5 years? Have you ever admitted for any treatment? Have you ever taken any treatment or surgery? Or so many questions will be there. Agent will come and simply take our signature. We don't know whatever is actually many cases the patient might have undergone some treatment, taken visited in a hospital, or might have even admitted in a hospital or taken. Or sometimes we won't do anything. Simply, sir, please sign proposal form, we'll sign without noticing anything. After taking the policy, unfortunately, the husband dies because of an accident, road accident. Then they will appoint an investigator. Insurance company will appoint an investigator. He will come to our house and ask so many details. You can get all medical papers or court papers, whatever you have. Poor people, ladies or other things, people without having any knowledge, they will bring whatever medical records they have. Then they will say, or suppose he is an employee. Employees also will adopt some things, saying that have you ever availed sick leave like that will be there. Have you ever got any treatment? Similar thing. Then you think that's okay. If he is an employee, if the insured is an employee and dies, they will first go to the office of the employer and take all the sick leaves. And for what reason he avoided sick leave? What was the disease? Then they will go to the hospital. And here also if any information is given and prescription are given by the ladies, then they will go to the respective hospitals and then investigate, saying and repeat the claim, saying that we have suppressed the health condition in the proposal at the time of taking the policy. He suffered from so-so disease. He has taken from so-so hospital. Employees, suppose employees, many people, though not suffering from any disease, they will take some medical certificate. Suppose marriage of daughter is there, or in your native place you want to construct a house, or if any other important works are there, for completing you will apply for leave for 15 days or 20 days or 1 month. Saying simply jaundice, no jaundice, simply jaundice certificate will be taken from the doctor and that will be given in the office and you will have a sick leave. This fellow will come and go to your office and take a leave particulars and go to the hospital. The doctor, so doctor has given treatment for you from jaundice, from so date. You have suppressed this at the time of taking the policy. So this is also suppression of health condition at the time of taking policy. They will then reject the claim, saying that you have adopted fraudulent method and taken the policy. So this you have played fraud while taking the insurance contract. We are rejecting the claim. Though that fellow might have died because of road accident, though there is a nexus between the alleged suppressed disease and the actual death, cause of death, in spite of saying they used to reject the claims like this. So you must be careful. And one more thing, employees are concerned. Employees will take insurance policies, life insurance, under salary savings scheme. The salary savings scheme, at the time of taking policy, the insurance company will take an authorization letter from you, authorizing your employer to deduct every month the premium and to send every month premium to the insurance company. Sometimes, for whatever reason, your boss may not collect the premium from you, may not deduct. Sometimes, even after deducting the premium from the salary of the employee, for whatever is some reason, they may fail to forward the premium amount to the insurance company. So, monthly premium is not paid, the policy automatically gets lapsed. Thereafter, if death occurs, then the insurance company rejects the claim, saying that no, for last 6 months or 3 months, we are not getting any premium, premium is not paid, policy is lapsed condition, we don't pay anything. On the ground, they used to repeated lakhs and lakhs of cases previously. Subsequently, the Consumer Protection Act, particularly insofar as salary saving is concerned, the Supreme Court said that here the employer, that is between the employer and employee has given authorization to the employer to deduct from the salary, and there is agreement between LIC insurance company and our employer, saying that that the employer has to deduct and pay to the insurance company. There was an agreement is there. So for the fault committed by employer, in fact he is nothing but an agent, principal and agent. For the fault on the part of the agent, the husband or wife, they cannot be find fault. So like this, the Supreme Court held that for the lapse of the policy under salary saving scheme, for the fault of the employer, so policy cannot be rejected, policy cannot be repeated. Like this, when Justice Jaiswal was the president of our state commission about 2 years back, about 500, 600 cases of this nature, he allowed the cases. Particularly employees from Singareni, all these employees, they have taken policies, premium amount substitute or lapsed, no intimation was given, and when he died and when claim is larger, they reject the claim and they wrote that no policy, premium was not paid, policy is not in continuation, it is lapsed, so we don't pay anything. So like this, life insurance as well as general insurance companies also will come. In general insurance company is concerned, if any claim is made, immediately they must appoint a surveyor. Surveyor has to assess the amount and then refer to the company. Based upon the whether terms and conditions, whether they are liable or not liable, they will do. If it is acceptable, they have to pay, or they have to reject the claim. They must immediately inform. Without any reason, the insurance claim is rejected or abnormally delayed, they are bound to pay principal amount along with interest also. So if they are not paid, we are entitled to approach the consumer commissions. We are getting number of life insurance cases, medical policies also. Most of the employees will be having medical policies. So when the patient is admitted to the hospital and they have to give cashless facility. In many cases, they used to refuse the cashless. First you undergo, you pay the payment, and thereafter coming to the bills, we will pursue the matter, we will scrutinize and pay. So without any valid reason, medical policies are rejected. They will reject on the ground that in many cases there was a pre-existing disease before taking the policy. Your husband was having so disease. He has not disclosed the same thing and he has taken the policy. He suppressed the previous health condition. So we are not, you are not entitled for any claim amount. Then we will repeat it. So case to case, if the unreasonably claims are repudiated, rejected, as a general insurance, life insurance, we are entitled for the some amount, and for the delay also we are entitled for interest also. So like this, many cases, each and every defective good, each and every deficient service, if any unfair package is adopted against us, and like the nature, we are entitled to approach the consumer commissions in a speedy way. Of course, speedy is the justice is one of the objectives, and compared to civil courts, somewhat reasonable period we are getting. So due to some various reasons, we are still getting delayed, and court fees will be very nominal. And with this, apart from our regular work in various courts, you can also practice, and for young students, because one of the important topic for you, for your academic purpose, because you are going to be prospective advocates, it will be very much useful to you. This just I think that I have given you a picture of this consumer protection. You can have some. No, If you are having any doubts, I am ready to clarify. I'll go there.
Those who ever want to ask any questions, you can write it on a slip and you can send it here. You can give it to Mr. Kranti. And now I invite our district president Praveen sir to come up on the dais, and also our AILU leader Venkateshana, please come up on the dais. And I request Mr. Sampath, convener, to address the gathering.
Yeah. Thank you all. Thanks for coming here. We have very short and thank you, sir. Thanks for inviting us regarding the Consumer Protection Act. I'm not going into the Consumer Protection Act, but I would like to enlighten you recent some of the features which is happening around the Consumer Protection Act. I would like to say the one statement that Consumer Protection Act needs your protection by the legal fraternity as well as the legal students. Why? Because recently there is a data which is showing that especially in Telangana, there is one report is published in the name of the Consumer Justice Ranking. I hope you all aware about this ranking. Surprisingly, we are the bottom at all the states. Bottom at all the states. Just we have only 2 points. Across the entire India, we are in the bottom. The main key reasons why we are in the bottom, because our state president post has been vacated for the last entire 4 years. One of the last student who taken as an initiative and filed a PL, Mr. Bagalkar, Akash Bagalkar is the one person who has filed the PL and fight for the 3.5 years. Then the government has been appointed the State Consumer Commission. And more interestingly, we have 33 districts and 12 districts are having only the district consumer commissions. There is no consumer commissions are there in the remaining 21 districts. I have filed myself PL in the Honorable High Court. Last 1 year onwards, I am fighting for that case. And the High Court is given direction to the government that you have to make sure the district commissions, as per the section 20 of the Act, it has to be there for each district. You have to institute every district one district consumer commission. The direction has been given by the Honorable High Court, but still the government has been not taken any single step. Out of the 12 district consumer commissions, 25%, that means 4 district consumer commission presidents are vacant. Only 8 are just only working. The act is so impressive, and that is really having a beautiful role. Not only the government, the real saver for any act. The act they are suppressing means it is very useful. The government suppressing, the government is making it is useless means it is very useful for the people. Very simple logic. We as a students are the legal fraternity. We must protect this kind of the acts. Otherwise, in generally what happens, people will lose their hopes on the act. So these are the latest glimpse on that. And thank you, sir. Thanks for coming and slips. Any doubt slips are there? Please share.
Can we just say orally? Please.
Why not? We will arrange the mic if you want.
I am audible. I am ready to.
Taki,
Please come here and
Please come here.
come here.
if you come and say something, it will be audible for everybody. It will be useful for everybody.
Myself, Vinod Bhatti here. I am a student of Usman University Law College. Yeah, I have one question related to, particularly related to real estates. Okay, how this consumer protection is different from RERA?
So RERA came recently, and a consumer can file either before RERA or Consumer Commission. It is his discretion. But RERA is a wider scope. But as far as the bottom is concerned, it is also very narrow. The thing is, for the applicability of RERA, the land must be minimum 500 square yards of on the land over 500, minimum 500 square yards of land any apartment is constructed, that attracts RERA. Small apartments where the landed area is less than 500 square yards, if any defect is there, I guess those builders must go to Consumer Commission only. And similarly, if the number of flats are more than 10 only, RERA will apply. Otherwise, for smaller apartments, it will not apply. So RERA is also good, and RERA is there, and it is that RERA appellate tribunal is also there. So it is a discretion of the court, complementary to each other.
I have a question related to this. Consideration is important in this aspect as to be considered as a consumer, right? But if the roads are defective and there we are not paying any consideration, then how can we?
So, already in Indian Medical Association versus VP Satta's case, it is argued the government doctors are not rendering any free service. They are getting salary from the taxes paid by the public. So that argument was rejected by Supreme Court. As far as under Consumer Protection Act is concerned, so for tax, as far as tax is concerned, it is mandatory, it is obligatory. We have no exception. We are bound to pay the tax, whether the government may provide any service or not. It is mandatory. For being called as a consumer, some sort of fees or price or charge, some amount or something to do or something not to do, some sort of consideration must be there. So, far as the Consumer Protection Act is concerned, this is like a bill. If you want, you can file a bill because of mandatory. In fact, I filed one bill before High Court about 25 years back before Kadimanagar city. In so as a Maneru Dam is there. There, after for constructing Maneru Dam, subsequently the toll gate was installed there. Toll gate was installed, and they for a particular period, they have totally got the money back by toll, and the period is over. In spite of the same, they are illegally continuing. So one consumer council from Karimnagar, they approached me. I filed a consumer complaint, and the High Court directed them to remove it. Similarly, there is some Ratna municipality case. Supreme Court said that if the municipalities are not able to maintain the roads and streets properly, it is better to, you may either beg or borrow funds from somewhere. Otherwise, you close down your municipality. So such a directions can be given. So it is better to submit a representative to the government, and if not, it is better to file a bill insofar as the complaints are like this nature. We can't file before Consumer Commission as far as this issue is concerned.
Myself, Bhavani Shankar from Padala Ramreddy College. So, my question is regarding the illustration which you have given. For example, a person from Hyderabad goes to Delhi and then he avails some service and he comes back to Hyderabad and then he wants to file a consumer complaint. You said it has been centralized the process now from the CPA 2019 onwards. So how does it work? Like, is it through e-filing you are looking at, or else appreciate if you can give an illustration on it. Thank you.
So from the place of the consumer, he can file the complaint before the state commissioner, national commissioner, or district, or state commissioner or district commission, wherever it may be. So mode of filing is previously is manual. Now it is made as mandatory. You have to file the complaint online. So each of the platform is there. You have to upload everything, and thereafter physically you have to file. Actually, when e-filing is there, physical demanding to file physical filing is not proper. But because right now they are not fully equipped. First they are asking, it is mandatory to file by uploading through this each of the data, and for the timing we must file physical copies, all copies sufficiently. So you did not go to Delhi, they will come to Hyderabad, or if they remain ex parte, you will get judgment. If not implement, you can file execution petition for the arrest from Hyderabad. So from the place of the consumer in the relevant district or state, you can file complaint. I also got some queries. Please continue. Please.
Good evening, I am Professor Gopinath from Padala Indian Law College. You said for free legal camps, even if death occurs, it doesn't come under Consumer Protection Act, even though it is due to negligence of doctor. Then where does the patient go for justice?
So in civil cases you can file. If there is no consideration, if the services are rendered free of charge, we are not consumer, we cannot file before consumer commission. The other options are we can file before the civil cases, civil courts, or you can also file a complaint against doctor on the medical council. They will take a disciplinary proceedings, disciplinary action they can take, or you can also file criminal case against doctor also, if you so think. All are independent. So as far as compensation is concerned, you can go either to consumer commission or civil court. If you are a consumer, you can file before consumer commission. Otherwise, you can go to civil court. You can also take all, including medical council case or even criminal case also you can file. One question. Overcharges, sir. Shall we challenge the government to overcharges? This first one. Government overcharges అంటే ఏంటండి? పేరు రాయలేదు. ప్లీజ్ కమ్. ఓవర్చార్జెస్ అంటే పండుగలకి బస్ చార్జెస్ ఎక్కువ పెట్టడం.
ఫస్ట్ ఓవర్ చార్జెస్ చెప్పండి. మన పబ్లిక్ ట్రాన్స్పోర్ట్ ఉంది కదా, పబ్లిక్ ట్రాన్స్పోర్ట్ మీద చూస్తున్నప్పుడు అంటే మనం ఇప్పుడు మన కన్జ్యూమర్స్ కాకపోయినా బెనిఫిషియర్స్ మనమే కాబట్టి, సో ఓవర్ చార్జెస్ని మనం ఎలా క్లెయిమ్ చేయొచ్చు? ఓవర్ చార్జెస్ పెంచేటప్పుడు దానికోసం అంటే ఎగ్జాంపుల్ అంటే ఇప్పుడు మీరు అందరూ సెలబ్రిటీస్కి ఉన్నారు కదా, అంటే మనం వాడుతున్న ప్రతి దానికి ఎలక్ట్రానిక్స్ గుడ్స్ కావచ్చు, తీసుకోవచ్చు.
ఇది this one, sir, shall we challenge the government overcharges? What is overcharge? What is not? We can't decide. So wherever any charges printed on the any price or charges, anything printed on the label of any article, they cannot sell more than that printed price. If not printed on the label, some growth, if you go to a hotel, they will give some menu card, some rate will be there. If they charge more than that, you can proceed. Or if the government fixes rates like oil or petrol or something, or any other essential commodities in the ration shops. So whatever rates prescribed by government, more than that, if they charge, you can question it. Sometimes they will sell lesser than MRP. If they sell for lesser price than MRP, they are entitled. But if you charge even 1 NP more than the MRP, we are entitled to question it. So the question is whether they are entitled to what is the extent of percentage for which they can enhance the price. That's what you are asking. Suppose liter petrol now we are having 100 rupees, 106 rupees, let's say. If that is increased, or any railway fare is increased, RTC fare is increased. Now we are not entitled. Because price structure will not come under the purview of any court. Price structure. This about 30 years back, one complaint came before our state commission when Justice Lakshman Rao was the president. There the milk, Vijaya milk, produced supplied throughout in the other place at that time. In Kurnool, they are charging some 25 paise more than Hyderabad per liter. That consumer association challenged that one. they say it is not prescribed by the government, it is a private one. For private person, private company, private authority, they are entitled unless the government fixes by of any price control order. Other products for which there is no control of the government. It is a bargain and taken bargaining only, we have to avail it or purchase it. So there is no course can go into the price structure, that is the point. No court can go into price structure. If whatever is said or printed on the label, if they charge more, then we can question. The very increasing, suppose this bottle is 20 rupees is printed. If they want, they can print 50 rupees or 100 rupees because there is no bar. In such cases, we have to bargain and take. We should not feel shy in bargaining. Then we can bargain with us all.
So during
Next,
festivals-
fake one he said. Fake, I say, kindly give me what some example, I will guide you properly.
So during festivals they
Oh,
increase
sir,
the
next time will come. Welcome.
ఫేషియల్ క్రీమ్స్ కానీ లేకుంటే మనం ప్రోటీన్ పౌడర్స్ ఇట్లా ఉంటాయి కదా, వాళ్ళు మనకి ఇస్తుంటే మనం యాడ్స్ చూసి తీసుకుంటున్నాం కదా. సో మనకు వచ్చిందని మనం వాళ్ళ మీద ఛాలెంజ్ చేయాలా లేకుంటే కంపెనీ మీద ఛాలెంజ్ చేయాలా?
No, whatever advertisement that is sponsored or acted by any person, any celebrity, whatever representations they are making in this ad, if they are not legally not permissible. Suppose you take an advertisement regarding this tobacco prohibited, or like this, if illegality is there, whatever the standards they say or specifications they say in the advertisement, if they are not true, in such cases that is treated as unfair, and Central Consumer Protection Act is Central CCPA, Central Consumer Protection Authority (CCPA) is entitled to impose fines as well as imprisonment. So whatever they represent, whatever they say in the representation in the advertisement, if those representations are found to be false, then they are liable for penalties and imprisonment. Sir, give us.
Sir, during festivals they generally arbitrarily increase their prices of RTC buses, right? But the RTC fares are fixed to some extent. And in such cases, how they the same question.
Regarding just for government authorities for increasing prices, if any, what regarding control you are asking. Suppose electricity is there, I will come. Electricity is there. Per unit for domestic this much, commercial this much, or industrial so, farmer so, like will be there. Suppose electricity authorities, if they wanted to increase the price, for under the Electricity Act, there is a Electricity Regulatory Commission is there. So all these people, the electricity producers, there are private people are there, government people are there, Genco, even private people are also generating hydroelectricity. So all are called as licenses and producers. So whenever they want to increase the price, they have to make a proposal before electricity regulatory authorities. And the electricity regulatory authorities, whenever they receive such a representations for enhancement, they will conduct meetings with different people, different areas, with the different people, and take public opinion, and basing upon the basis on what basis they want to increase, what is the cost of production have increased or whatever may be. So based on that, whatever they feel reasonable, they will permit to increase to certain extent. For like that, for electricity is there. Artists is also, though autonomous body, still under the control of the government. So with the approval of the government only, they may increase. There is no bar, I think, sir, as far as RTC charges are concerned. Even railways are also similar.
Hello, I'm Sanjeev, first year business advocate. So in fact, I have three small questions. First is, last year September, the central government had reduced the GST from 28 to 80%, 18 and something to 5%. But in fact, I had seen in some of the billings which was given by the medical shops, they were selling at the same price, that MRP. Whereas the government lately said that the GST is reduced, you should reduce the GST and pass on the reduced benefit to the customer, which was not done. In fact, when I argued in one of the medical shop, he said, no sir, the company has increased the gross margin and they were offset against the reduced GST. It was a verbal thing which is very unfair. And in such cases, do you receive any such cases? And how does one approach and file suit? In fact, we have already lost 6 months' time. So in fact, I had some talk with one of the advocate also. He said, no, it's very difficult to prove because GST has to be mentioned separately, the state GST and the central GST. And if it is not mentioned separately, then how do you prove what is the GST part, what is the margin part? See, this is the first question. Second is,
Let me complete.
Sir, we are not concerned about the margin part. So whatever GST prescribed by the government, that alone they can collect. When the government reduces GST, the reduced GST alone they are entitled to collect. In spite of that, they are collecting old GST, which is detrimental to our interest. We are entitled to claim for refund of this same. That is one thing. Second, please, we can approach the Consumer Commission for refund of the excess price, excess amount collected from us. And if you lodge a complaint with the GST authorities, they will take departmental action, very serious action they will take. If you are having evidence, you please send a representation to them demanding for a refund of the amount because it's a small amount first. If it is there not honored, then you can file it before Consumer Commission. Definitely it will be refunded to you.
and my second question, sir, misleading advertisement. There's a very famous advertisement which comes in the TV. Like 450 rupees you pay per month and you get a medical policy. And the moment within 1 month the person falls ill and undergoes a surgery, the medical person will come and clear 1 crore of bill, which is totally misleading and bullshit. I mean, I'm sorry I'm using that word. But in such cases, can we sue such companies who are giving this misleading advertisement? I'm so happy that I just pay 550 rupees and I'm able to undergo a surgery and the insurance person will come on the first day and clear all my bills, which is totally, misleading. I mean, totally, you're taking the consumer to heaven without,
Sir, it goes without saying that all the payments will be made subject to the terms and conditions of the policy. So, in some cases, like medical health policies, for a minimum first 2 years or 3 years, if any claim occurs, they won't pay. As per the terms and conditions only. In some cases, if any suicide is committed within 1 year or 2 years of, like this, they are subject to terms and conditions. So we must go through all the terms and conditions. The advertisement, all those things will not be, cannot be. So there is always subject to the terms and conditions. Even in the LIC policy, most of 90% of us will not read the terms and conditions. Even otherwise also we are bound by the terms and conditions. Before that, we have to go through.
One small question. You see, when any patient is getting admitted to a hospital, there will be some kind of slab system, like if you have a single room, a double sharing room, or general ward. But the charges, the surgery for the same operation, if you take a single room, your surgery charges are 4 lakhs. And if you take a double sharing room, it's 2 lakhs. If you take a general ward, 50,000. Well, for the same surgery, same doctor operating, and you're charging the different rate for surgery just based on the room which you are taking. I mean, how far it is reasonable? In fact, all the corporate hospitals, they follow this practice, like, as we are all aware of that. How does can we really file a bill or on this Consumer Protection Act? I don't know which section will address this kind of an issue, which is very well known commonly to all the people.
Actually, sir, there is a provision that whatever price charges being collected by hospitals, they are bound to display the names and particulars of the treating doctors, the type of surgeries or type of operations or investigation done. They have to give all the display board. They have to put, or otherwise they have to on demand. They have to furnish to us. This kind of practice for the same operation will be same.
The room you take, it depends.
Yes. That is unfair. That is unfair. No, in some cases where there is no law, we have to bargain with ourselves, sir. If you go to vegetables, we have to bargain ourselves. There is no law. Price is not prescribed there. Sir, one more thing. I have been appointed by the government of Telangana as a member in Telangana State Council for Clinical Establishments. It means for doctors, all the doctors must register with the Indian Medical Association, Medical Council. Advocates, we must enroll along with the Bar Council. Similarly, all the hospitals, clinics, establishments, diagnostic centers, medical laboratories, everything, they must also register with the Clinical Establishment Act. So if any violations are there, if they are not properly, not registered against any complaint against that, you can lodge with the clinical establishment council will be there. For every district there will be DMH will be the head, another district committee will be there, and I am a member in the state clinical council. I am a member there. They can also impose fines or taxes, or even ask grant for shutting down the hospitals like that in appropriate cases.
The certificates also they should display.
Yes, there is a law.
So, but the cost of the whole thing.
We can see later because there are so many things are there.
So I purchased a product and later subsequently I found it defective.
Louder.
Subsequently I found it defective. Then complaint shall be raised on vendor, trader or manufacturer, or I can repeat all the things. And
First of all, it is a manufacturing defect. We must include the manufacturer as a party, or otherwise they are sealed packets, sealed tins, or the sealed bottles. Then you have to make the manufacturer compulsory as a party. If they are loose, you have to compulsory retail must include the retailer also, not also must include the retailer. So depending upon that, in any vehicle or any product, the company. It is better to include manufacturing defect, dealer as well as manufacturer. If it is a loose one, we have to fight against this kind of thing.
so one more. Can we, I raised a complaint in consumer court. The same term parallelly, can I file the case in civil and in other forums also simultaneously, or only one forum I can do?
No, sir, as these monetary complaints are concerned, if you must go only parallel, you cannot go parallel. If you want, you can take a consumer complaint, or you can file civil complaint for compensation. So as doctors are concerned, I told you can file before compensation before the consumer forum
And also in medical.
or civil court. Only option is either this or that. Simultaneously you cannot file both. But medical council and criminal case, they are different. You can parallel proceed.
So one more.
Sir, please wait. So many things are there. You can. What is the most tough, complicated case we have handled under consumer protection law in your area? ఇందాక చెప్పాను కదండి అది ఓన్లీ బికాస్ ఆఫ్ మై luck of the client only, or otherwise 100% that case would have been dismissed because doctor simply suppressed it. Patient got post-mortem report with him. He doesn't know the contents of post-mortem report. Post-mortem report is very clear. 6 sutures are there to the bladder. The doctor suppressed it. Doctor never mentioned. Only out of my flash, so many cases, about 1,000 cases I have done. Number of medical. I have filed cases, argued cases under the doctors. About more than 100 cases have done. Almost all famous hospitals in the entire AP Telangana I have filed. Aన్నిటికంటే tough case అంటే medical case is tough. మిగతా కేసులు అన్నిటికంటే కూడా మెడికల్ కేసెస్ టఫ్. ఒక మెడికల్ కేసు ఒక అడ్వకేట్ చేస్తే బాగా చాలా ఎక్స్పీరియన్స్ వస్తుంది.
Sir, any dental related cases, sir?
డెంటల్ కూడా వస్తుంది. డెంటల్
He's a dentist.
పర్లేదు, అడ్వకేట్స్ మీద కూడా గతాలు వచ్చాయి. కానీ సుప్రీం కోర్ట్ రీసెంట్లీ సెడ్ దట్ నో కంప్లైంట్ కెన్ బి ఫైల్డ్ అగైన్స్ట్ అడ్వకేట్స్. ఇంకో ఫ్యూచర్లో ఐ థింక్ వైల్ exonerating the liability of the advocates under Consumer Protection Act, in the same judgment, Supreme Court observed that same parallels applies to the doctors also. In appropriate case, this issue of the doctors must be revisited by the Supreme Court. Earlier, a number of it is settled that complaint against doctors is better. Supreme Court, while deciding the advocates' cases, Supreme Court said that advocates will not come. In the same case, observed that 2 paragraphs observation is made. The doctors are also similarly situated. Because already judgment is there against the doctors, the Supreme Court has to reconsider it in appropriate case. That is observation made. In future, any person again takes to Supreme Court, any doctor, again it will be there is possibility. ఒకటి చూసాను సార్, ఎందుకంటే నేను ఐ ఆల్సో అపీలింగ్ ఫర్ ది అడ్వకేట్స్ డాక్టర్స్ ఆల్సో. I have seen so many things, but it's a very unfortunate to have a medical case against doctor. So it is a black spot, not only black spot in the doctor, but in many cases, due to lack of knowledge, simply patient died means doctor negligence antuntaru, correct కాదు, case to case ఉంటుంది. So ఈ judges కూడా they are also illiterate as far as medicine is concerned. So hard and fast rule we cannot say. నేను ఒక కేసు చెప్తాను. నా క్లయింట్ ఒక పెద్ద డాక్టర్ ఆంధ్రప్రదేశ్లో ఫస్ట్ కిడ్నీ ట్రాన్స్ప్లాంటేషన్ చేశారు డాక్టర్. ఆయన ఇప్పుడు చనిపోయారు. ఆయన ఇప్పుడు ఏంటంటే ఓ పేషెంట్కి వాటికి చీక్స్ మీద ట్యూమర్స్ బిల్ల లాంటివి వచ్చినాయి. లోకల్ అనస్థిషియా చేసి రిమూవ్ చేసిన ఫస్ట్. నెక్స్ట్ డే ఫర్ సేమ్ పేషెంట్ సేమ్ అనస్థిషియా వాస్ గివెన్ ఫర్ ద రైట్ సైడ్. ఇమీడియట్లీ రియాక్షన్ కేమ్, కొలాప్స్ అండ్ డైడ్. ఇంకా whether
submit claims in consumer forums, how to recognize effective services by the consumers. Is it possible to do effective services in all cases?
So first one is now we have to file the consumer complaints. The question is whether any particular farmers performs required to submit claims in consumer forum. Now in the prescribed format you have to file. If form this e-geography platform through online you have to file. Several documents are required to be filed. So perform is there. How to retain defective service? Sir, defective service means it depends that particular what is the service hired, what was the specific allegation. Doctor with deficiency, లేకపోతే రైల్వే డెఫిషియన్సీ, హోటల్ అడల్టరేషన్ స్పెసిఫిక్ ఉండాలి. సో వీ మస్ట్ స్పెసిఫిక్లీ మెన్షన్ వాట్ వాజ్ ది డెఫిషియన్సీ, వాట్ ఇస్ ద ప్రాబ్లమ్, వాట్ ఇస్ ద ఫాల్ట్ ఆన్ ది పార్ట్ ఆఫ్ సర్వీస్ ప్రొవైడర్, హౌ టు ప్రూవ్ ఇట్. ఇన్వాయిస్ ఉండాలి, బిల్ ఉండాలి, కరెస్పాండెన్స్ చేయాలి, వాట్ ఇస్ ద రెస్పాన్స్ చూసుకోవాలి, అది కరెక్ట్గా ఉందో చూడాలా, లాఫుల్గా ఉందో చూడాలా. దెన్ వీ హ్యావ్ టు ఫైల్ ది కంప్లైంట్.
Sir, as per the definition of consumer, the end, whether a farmer is a consumer.
Yes, farmer is a consumer. So as per the definition of consumer, the end user called consumer. So in that sense, farmer. No, farmer end consumer question. So ultimately, whether a farmer is a consumer or not, farmer purchases pesticides, fertilizers, takes insurance policy, takes a tractor, purchase tractors, or so many equipment. So farmers, Supreme Court clearly held that they are consumers. So though they may purchase one packet of cotton mirchi seeds and sprays in their 2 acres of land, and you will get 40 quintals of chili, and you will sell 40 quintals of chili in the market. So by purchasing 1,000 rupees seeds, he is selling for 5 lakhs chili. Is it not commercial purpose? The Supreme Court said that trade is different from agriculture. Agriculture is totally different. So the agriculture is a farmer is a consumer. So we cannot equate the agriculture with other trade or business.
So whether it is reasonable for farmer.
Okay, Rendam sir.
If a internet service provider took amount of 3,000 in cash and 350 through GPay, how can I file a case against them? If yes, how?
The question is, if a internet service provider took an amount of 3,000 in cash and 350 through GPay, how can file a case against them? Is to how?
If yes, how?
If yes, sir. One thing, sir, first is always proper to take proper receipt, or some proper mode of payment must be there, or otherwise it is very difficult to prove. Even otherwise also, in case of murder or theft, nobody will be there, no witness will be there. After so many investigations, there is a possibility and murders will be caught hold of. Based upon the other circumstantial evidence. If in this case, if you make some SMS or another email, or if they give a response, if they admit, if like such a sort of evidence is there, you can file a complaint. or any other person is there along with you while paying the amount, you can file affidavit. But chances without evidence is difficult. You please make it. Last one, sir.
What are the emerging areas of consumer law or consumer law? Why should anyone practice consumer profession over civil or criminal law? What skills should be young or new lawyer build by consumer law? Students.
But insofar as students are concerned, what are the emerging areas of consumer law or consumer law? Why should anyone practice consumer protection law over civil or criminal law? What skills should a young lawyer build in consumer law? So it is better to have separate session on this topic for the young advocates or students who wish to pursue legal profession. This is also it is a ocean. So, if you want to become a perfect advocate, it is always better to practice in lower courts at least for 3 to 4 years, so that you will be knowing fundamentals. If you directly go and join with an advocate, Supreme Court advocate in Delhi, you don't know ABCDs. ABCDs, fundamental basics you don't know. Suppose if your neighbor comes, sir, policeman made a phone call, what I have to do? Or promise not how much revenue stamp I have to quote. Rental agreement, how to I write. Supreme Court advocate will not write. He doesn't know. He won't see. Like that, super specialist doctors will go to for a headache. So he really feels a neighbor. Sir, I am getting a headache. Can you prescribe some tablet? He won't prescribe. I'm a heart specialist. I want to take this headache matter. So like this, fundamentals we will learn from lower trial courts only. First practice there. So this civil, criminal, consumer, all those things will come automatically. If you are an expert civil advocate, they are very simple. For a lower court advocate, high court practice is very simple. Not even 1/4 of work will be there. We will work very hard in lower courts only. It's very difficult to complete the process from time of filing till the date of disposal. So the advocates practice in lower courts, they will be very hard working, knowing practical knowledge and various procedural laws they will know. It's better for any advocate. I don't directly go and join a consumer forum or practice consumer commission. You know that advocates practicing in criminal side, they won't take up in a single civil case. Their mind will not even permit. It is very difficult. So the work is easy. You know, for a high court, a regular high court advocate, you won't go to lower court because the process is more. So first of all, you can practice before lower courts, and whenever you want a Supreme Court, high court, you can go later.
So last question. Is it consumer protection? Is it applicable for second-hand products also? For second-hand product, second-hand. Example, if you buy second-hand vehicles.
Even if it is second-hand product, it all depends upon the terms and conditions. They will also give warranty guarantee for some period, or a minimum if a purchase of goods for minimum period they have to work. If they do not work, or immediately they fail, you can also file, depending upon the nature of the product you purchase.
Sir, thank you. Mr. Pradeep, please, now time is up now. We have to